Hello, attorney broker John McConnin here, and today we're going to talk about California law and whether it's okay for a realtor to pay a referral fee to an attorney. And we're also going to talk about RESPA, national law. And I'm also going to flip it because it takes too long going the other way. One, if an attorney may be paid for services rendered, and there are a lot of services an attorney can render on a real estate purchase and sale transaction, from reviewing the listing contract if you're working on the seller side, the purchase and sale contract, and then I see all the time coming up right into closing. Usually, disclosures are made, and you might want to review those too. But then things are going smoothly, and then sometime about a week before, 5 days before, 3 days before the closing, all of a sudden the file goes through what lenders might call a quality check, or escrow starts getting really serious and saying, okay, well, we did the forms before, but now we got to pay attention. And all of a sudden they start asking clients to sign some odd documents. Sometimes they're CYA documents. Sometimes they're California Franchise Tax Board documents that are odd, especially the first few times you see them. Escrow can sometimes start making clients jump through hoops. Lenders can make clients jump through hoops. And many times, not all the time, but many times, these might be compromising your client's position or safety, or they're just unnecessary and could cause delay, which, if they're back-to-back purchase and sale that your client's doing, that delay can be harmful. So at that point in time, I've noticed that realtors sometimes get nowhere. They just say, this is how we do it. This is the form. This is what we're doing. Where I might call up and say, hey, I understand you normally have forms, but if we need to, I have no problem talking to your legal department about this. But what we're doing is sort of hurting my client or hurting the transaction. It's completely unnecessary, and it's not what we agreed to in the purchase and sale agreement. And it's not even in escrow documents. Frequently change the purchase and sale agreement. They deny they do it, but that's there, and that's why you got to pay attention to those. But they'll change things, but they won't cover this change, and all of a sudden they're changing things that can compromise the file. I've noticed that when you approach it reasonably and say, hey, I need to talk to a lawyer over there and we can get this worked out, they frequently, almost actually all the time, initially, no, they put up some resistance, but now I've dealt with almost all the title companies here. And if I'm asking, I'm not walking and saying, I'm a lawyer, it's got to be done this way. I'm saying, no, what we're doing here doesn't make any sense for the transaction, so let's make it make sense. Besides, there's no reason to do it your way. I've had them agree to my way every time since, like years ago, the first few times. So maybe it's experience knowing when to ask for it and knowing when to make a stand. Maybe their legal departments now know that, I know what I'm talking about. But nevertheless, a lawyer can be working right up until the closing, and they're important. So you're going to refer it out to a realtor, hopefully me, to do the real estate work. But you are going to want to, if you're working with me, we're going to talk about what the listing contract can look like. We can write clauses in to protect your client, like they can cancel at any time. Purchase and sale agreement, we're going to talk about how to protect the client, and maybe we'll have a template that we agreed to ahead of time. The only thing that will change will be price and terms if they're buyers. If they're sellers, we'll discuss the merits of the counter. But there's forms, and then there's experience. I know lawyers are very useful, so I have no problem. And I like having second sets of eyeballs on the transaction too, especially if it's really important to probate. Big money might be involved. You've got a client that you've had a long-term relationship with and you want it to get done right. No problem. So, you say, hey, I recommend John on the file. We talk, you say, hey, I'd like to put in some time overseeing the transaction. And we work out, it's a lot easier to do a flat fee because, once the HUD gets finalized, if you go back and say, well, I just put in 2 more hours, so let me charge more, that could cause problems. It might even stop the transaction from closing on time. So, I think we should work out a flat fee. I understand a lot of work can be involved, so I don't mind the fee being significant as long as it's related to the transaction. We can work that out. Now, so services rendered, lawyers can get paid. They can even get paid on the HUD. Second, referral fees. Well, and here where I might shrink down, depending on how good I am with my skills, I might shrink down and move over to, here's RESPA, prohibitions against kickbacks. And it says, nothing in this section shall be construed as prohibiting the payment of a fee to attorneys at law for services actually rendered. So, under RESPA, realtors are not supposed to give referral fees for transactions covered by RESPA, and they cover just about anything with a loan in a residential transaction, and maybe more. Maybe there's times it's not even a loan. Now, I think it's an overreach on RESPA to say that because they're really trying to protect the lenders from overpaying for properties and illegal kickbacks and all that stuff. But that's the way the law is. That's the way it's interpreted by a lot of experts. And I'm sure that's the way a lot of judges would rule. Why dig deep in and really understand the point of the law when you can just make a blanket ruling? So I would say it's probably best to not expect realtors or accept referral fees from realtors if it's a RESPA covered transaction. If it's not covered by RESPA, here's another interesting thing about referral fees. Not the services rendered getting paid fee, but a referral fee. Other commentators that I trust feel that under California law, or it's not feel, it is, under California law, a realtor may make a referral as long as the person receiving the referral didn't do any work that requires a real estate license. And oddly, some lawyers interpret that as meaning it would be difficult for a realtor to pay a fee to a lawyer if a lawyer's done legal work on the file, like negotiating negotiating or drafting the contract if it's following the form contract. So I don't really buy that interpretation, because I know that the lawyers have this whole section of law, and we've carved out stuff that realtors can do if they're using forms, and CAR makes forms, so realtors don't have to practice law. I understand all that. But the point is, referral fee, stay away if it's RESPA covered. You probably want to do work to receive your referral fee. So basically, you probably never want to receive a referral fee. You would like to get paid for services rendered. And I think lawyers should be involved in real estate transactions. I really do. I'll make another video about that. But it's not just forms all the time. There's legal work that's being done. And I think lawyers should be doing it, and they should be getting paid from the realtors. So I have no problem doing it on my part. I welcome it. So if you'd like, it's going to be at favoriterealestate.com. Click on I have a lot of contact boxes, or call me. You can use the number on the site, or just call me now, 760-896-4663. Thanks.